Indeed, Mr. Speaker, it is true that I moved a motion to defer debate on the motions for the establishment of the committees in terms of membership because it looked like there was a bit of a disagreement, and asked the leadership to be given time to consult and thereafter, if possible, to hold a Kamkunji. I think we have generally consulted and agreed, and at yesterday's Senate Business Committee meeting, it was agreed that that consultation is necessary. On the part of the minority side, we are holding consultations tomorrow, and after our consultations, then we hope that we can meet with the majority side. And it's not a consultation which is exclusive. At least on the minority side, all the members will attend that consultations so that there is some consensus before the list is reintroduced into the chamber. But it was a resolution of the Senate Business Committee yesterday that we need to consult and the Kamkunji is required. I was hoping that tomorrow we'll approach your office and agree on that Kamkunji to be held next week. I know it is an urgent matter, like the Committee on Devolution cannot meet because they do not have enough membership at the moment. But I think it is important to have some consensus before the matter is formally introduced in the House.
That's okay. I will be available tomorrow for that consultation and direction. And I think it's important that the committees are constituted, because I'm also aware that we have members here who are not on any committees and they need to participate in what goes on in the committees. Next order.
Order number 8, motion. Censure of Honorable John K. Munyes, Cabinet Secretary for Petroleum and Mining, and Honorable Charles Keter, Cabinet Secretary for Energy.
Mr. Speaker, sir, I rise to move the following motion. That aware that on the 15th of September 2021, a statement was requested under Standing Order number 48-1 regarding the recent increase of fuel prices by the Energy and Petroleum Regulatory Authority, that is EPRA. And whereas the Speaker of the Senate directed the Standing Committee on Energy to invite the Cabinet Secretaries of the Ministries of Petroleum and Mining and the Ministry of Energy to appear before the committee on Tuesday, the 21st September 2021, to apprise the committee and the entire Senate on the unprecedented escalation of fuel prices in the country. And whereas the Standing Committee on Energy invited the two Cabinet Secretaries pursuant to Article 153, sub-articles 3 and 4 of the Constitution, to appear before the committee on Tuesday, 21st September 2021 at 11 a.m., noting that the said Cabinet Secretaries failed to honor the invitation to attend the meeting of the committee. Cognizant of the fact that the sharp increase in fuel prices in the country has had a ripple adverse effect on the economy, leading to a rise in the cost of living and the cost of doing business on an already overburdened citizenry grappling with the effects of the COVID-19 pandemic. Further, aware that this increase in fuel prices has outraged a majority of Kenyans who bear the brunt of the effects of the increase, such as high costs of transportation, high food prices, high cost of electricity, among other adverse effects on most sectors of the economy. Now, therefore, the Senate expresses its grave concern on the unprecedented increase in fuel and electricity costs and the adverse effects that these have had on the economy and livelihoods of the people of Kenya, and to expresses its dissatisfaction with the conduct of the two cabinet secretaries, namely Honorable John K. Munyes, Cabinet Secretary for Petroleum and Mining, and Honorable Charles Keter, Cabinet Secretary for Energy, in failing to appear before the Senate to address these urgent issues, thereby abdicating their responsibilities as set out in Article 153, Sub-Articles 3 and 4 of the Constitution. Mr. Speaker, sir, in moving this motion, first of all, let me commend the Committee on Energy and its chairman, because it has tried to grapple with this matter over time. And indeed, looking at the business of that committee, and I've had the occasion to look at their deliberations and even previous meetings before there was this escalation. It is a matter that has been appearing in the proceedings of the committee for over a period of time. And it was as if they knew this matter was going to come to its present status, where it has escalated and has been compounded with factors such as the COVID-19 pandemic. And I know that the chairman has sought on several occasions to bring to the notice of the House legislation on these matters generally, as enacted previously and in previous parliaments. And when this issue now arose beyond the capacities of the committee, questions were raised on the floor of this House. And I think it was both the distinguished senators from Nandi and the nominated senator from Kisumu County desired that statements be made on this very important issue. And the chairman again responded, but it was the feeling of the House that this matter now required the executive, the responsible cabinet secretaries, to appear before the House and in a committee of the whole House, not the Committee of the Energy, to give explanation on this very important matter that affects the lives of all our people, people in business, ordinary citizens, going about their lives. And it was not without significance that the Speaker ordered that the two cabinet secretaries appear before the Committee of the Whole. And of course, yesterday, the House, the Committee of the Whole met, but the cabinet secretaries did not attend. And I think part of the influence of the House was that not the fact that there was non-compliance and contempt for the House for purposes of these particular proceedings on the rising costs of fuel and electricity, but also the appearance before various committees of the cabinet, various cabinet secretaries before various committees had taken a very bad turn, because it was notorious by the very non-observance by the cabinet secretaries, whether they were invited or summoned. And you have some cabinet secretaries responding, not even officially, to these invitations by saying that the matter is not a part of their docket, or that the Senate does not have those responsibilities. And I think this is an important occasion on when we can send a message clearly to the executive, because this is something that does not apply just to individual cabinet secretaries, including the ones we wish to censure today, but to all other public officers who have a duty to appear when invited or when summoned by Parliament, including the Senate. Now, it is important also to note the significance of a censure motion. The censure motion may be a little different from a motion of no confidence, but I think the effect and impact on the individual ministers or cabinet secretary is more or less the same. Under our present constitutional order, there must be an appropriate process for the removal of a cabinet secretary, but that does not mean that this House cannot censure or express its lack of confidence on any individual cabinet secretary. And this thing is so serious, and I want to remind the House and those who are here before, including the Attorney General Emeritus, motions of censure or motions of no confidence on various cabinet secretaries, and at that time they were called ministers, have been moved in Parliament. And the significance of moving those motions was never lost, not just to Parliament, but to the executive and to the individual cabinet secretaries who are subject to motions of no confidence or motion of censure. And the practice has been, in Kenya, at least in one incident that I can demonstrate, and elsewhere in the Commonwealth, or even in a system where they practice pure presidential systems, that when a motion of censure is moved by Parliament or any of the chambers of Parliament, willy-nilly you'll find that the cabinet secretary or the minister would resign even before the matter is discussed. Or they would not defend themselves. They will hear what Parliament has to say, and then they will resign. If the motion is against the leader of government, then willy-nilly, not only will that leader resign, but the entire ministers would resign, because there has been an expression of no confidence on the leader of the government. And, you know, this is what happened on the 27th of April, 1989, when there was a motion of no confidence. And I hope Senator Watangula would correct me if I'm wrong, that under the old constitution, there was provision for moving a motion of no confidence on the government of the Republic of Kenya. But there was no procedure for movement, no clear procedures for censuring or moving a motion of no confidence against a minister. But willy-nilly, over the years, there were such motions moved. But one of them, which was critical, was the motion of no confidence moved on the 27th of April, 1989, against the Vice President, Mr. Josephat Karanja. And he did not defend himself. He resigned. And I should quickly add that that motion does not arise out of non-compliance with the summons, failure to honor a summons, or failure to honor an invitation. But what I'm trying to say, that when Parliament expresses itself on a motion like this, its significance is enormous. And the practice in the House of Commons, and I've been doing some little reading, and even in a presidential system like in the United States of America, where on certain occasions the Congress would express its displeasure on the behavior or conduct of federal officials. Once those motions hit the floor of the House, the concerned parties at least would show seriousness, and a lot of them would even, before the motion is moved, try to purge the contempt. They would try to plead to the Speaker or reach out to the leader of the House, be it the majority leader or the minority leader, or use any one of the members of Parliament to purge the contempt and even convince Parliament or the relevant committee or the relevant member not to proceed with the motion because of the consequences of the motion, which, according to the Constitution, does not result in a removal, but it's so weighty that it cannot be taken lightly by the individual cabinet secretary. In these instances, even from yesterday and the week before, when we have been engaged with this matter, in the hope that they would try to purge the contempt or reach out to give some explanation, nothing of the sort has happened, at least to my knowledge, except on the part of the Cabinet Secretary in charge of energy, who, through the distinguished senator from Turkana, informed me that he was landing in Turkana with a delegation from southern Sudan. But that being so, and that may be an exigency of duty, I've known that when a motion of this nature is pending before Parliament, whatever the exigencies of duty are, the public official will defer to Parliament first before attending to those other duties. But in this instance, the way Parliament is being treated is that when you have some other business, whatever it is, then that business is important than the invitation or summons by Parliament. And I think this practice must really stop, and we must speak loudly on this occasion to remind those concerned that a summon or an invitation by the Houses of Parliament is an important instrument, is an important instrument under the law, and which requires those concerned parties to appear before either the National Assembly or the Senate. And I would, Mr. Speaker, commend the practice amongst the executive members in South Africa, because for them, even the president, when he is summoned, he appears. All of them appears. But in our instance, particularly for the Senate, this is becoming a practice that continues to take place unabated, and is a malfunction that must be corrected. Mr. Speaker, you would remember that in the old days, when you received a summon from a chief under the Chiefs Act and you failed to attend, it had consequences. And until that act was amended, if you disobeyed an order by the chief, you could be prosecuted. Although under the law, under that act to be prosecuted, consent was required from the Attorney General. And I'm glad that for the moment the Attorney General Emeritus was Attorney General, he never gave consent for a member of Parliament to be prosecuted for disobeying an order from the chief. But people tended to obey the orders. Now, Mr. Speaker, this summons, just to recapitulate what the law itself says, because some people may think that we are just acting in vain, and there's no legal basis for us to do these things. And, Mr. Speaker, as contained in the body of the motion, the appropriate articles of the Constitution have been cited, and that is Article 153, Sub-Article 3. And I think we have referred to this article many times in this House. And for what it is worth, because it has been read many times in this House, let me just read it again. And it says, Sub-Article 3, a cabinet secretary shall attend before a committee of the National Assembly or the Senate when required by the committee and answer any question concerning a matter for which the cabinet secretary is responsible. For purposes of the invitation regarding the two cabinet secretaries, we are talking about electricity and fuel. And obviously, there is no doubt that they're being called upon to answer on questions that relate to their responsibilities under their particular area of jurisdiction. And, Mr. Speaker, that is also in consonance with the oath of office that they took, the solemn oath of affirmation of due execution of office for cabinet secretaries. When they were appointed and before they took responsibility, they had to subscribe to this oath as required under the Constitution, because the Constitution says you cannot take those responsibilities before you take the appropriate oath. And that oath required of cabinet secretaries to obey and respect and uphold this Constitution of Kenya and other laws of the Republic of Kenya. And so far, I'm dealt with the Constitution, the constitutional provisions, which require that they attend when they are required to do so. And then this oath, to leave the matter, not in doubt, says as much. And then there's the general power of Parliament, again for record, because this has been quoted many times, cited many times in this House, in relation to the power of Parliament to call for evidence. And calling for evidence applies not only to the House itself, but also to committees. And it says, Article 125, Sub-Article 2, for the purposes of Clause 1, a House of Parliament and any of its committees has the same powers as the High Court to enforce the attendance of witnesses and examine them on oath, affirmation, or otherwise. B, to compel the production of documents, and C, to issue a commission or request to examine witnesses. So the Constitution itself talks about the power to call witnesses, or to call for evidence, or to summon any person. But it says if you do not attend or you do not appear, then the Senate will have the powers of the High Court, not of the Magistrates' Court, because those of you who appear before a Magistrates' Court, if you disobey an order by a magistrate, the consequences are dire. Or even a police officer, when you are appropriately summoned to appear before a police station. And many of us here have been required to appear before a police officer or before a police station. But in this respect, Parliament is given the powers of a superior court to compel the power to enforce the attendance of witnesses. And it does not say that, witnesses can only be ordinary mortals. Witnesses includes anybody, a citizen or a citizen or a non-citizen of Kenya. So these things is good to put them in context. And then the mother of them all are the Powers and Privileges Act. And again, these have been cited before this House. But for purposes of record again, Mr. Speaker, you allow me to cite them. There is Section 18 of the Parliamentary Powers and Privileges Act, summoning of witnesses. And that Section 18 has the heading Invitation and Summoning of Witnesses. And it says, Parliament or its committees may invite or summon any person to appear before it for the purpose of giving evidence or providing any information, paper, book, record, or document in the possession or under the control of that person. And in this respect, Parliament and its committees shall have the same powers as the High Court, as specified in Article 125 of the Constitution. So this power under the Powers and Privileges Act is so important because it is a derivative of the Constitution. They flow from the Constitution itself. And then Section 19 deals with the procedure of if witnesses fail to appear. And in this regard, the law is telling us that, if witnesses fail to appear, you are not a toothless bulldog. You are given these powers. And it says, where a witness summoned does not appear, or appears but fails to satisfy the relevant House of Parliament or committee, the relevant House or committee may impose upon the witness such fine not exceeding 500,000 shillings, and having regard to the witness's condition in life and all the circumstances of the case. And now we are not talking about an ordinary mortal. The circumstance in this case is a cabinet secretary who has taken oath or subscribed to an oath, who has got an office, a public office, and in the exercise of that public office, the law requires that they appear. Then, for interest, there is another very important section in the Powers and Privileges Act, Parliamentary Powers and Privileges Act, which I think we should always bear in mind, because it talks about public officers. And it says, no public officer shall refuse, and I shall repeat, no public officer shall refuse to produce before Parliament or a committee any paper, book, or record or document, or give evidence before Parliament or a committee relating to the correspondence of any national security organ. So even when it concerns national security, which would be the best excuse for any cabinet secretary to give, Parliament says, this act says, you cannot use national security as a basis of refusing to produce a document or to give evidence or to appear. And I think these are very important in terms of giving context to this matter. So we have these powers, not made ordinarily by us because they flow from the Constitution, and they have a purpose. They have a purpose. And I want to say and share with you, and I hope you will agree with me, that for cabinet secretaries to appear before Parliament, it serves a constitutional purpose, as set out in Article 10 of the Constitution, for purposes of transparency, for purposes of good governance, for purposes of accountability, and also for purposes of public participation when decisions are being made. Because, the sovereign, which is the people, when we require members of the government to appear before us, we do so on behalf of the people. And that flows from Article 1, Sub-Article 1 of the Constitution. So there's a constitutional purpose and objective. It is not just a law made out of context. It's a law that serves a constitutional purpose. So my brothers and sisters, honorable senators, I think this is a matter in which we have to come in forcefully for purposes of not just this Senate, but for future parliaments. Because if we have an executive that is not prepared to be accountable to the people, because now the people are crying out there about this fuel and electricity costs. And those who have been given this responsibility want to know why. And in exercise of our duty as elected representatives of the people, we have summoned the people concerned to appear before Parliament to give that explanation. And they have failed to do so. Now, I think that if you ask me, this is a matter in which there is no reason, there is nothing that has been placed before the House that can demonstrate that the Cabinet Secretaries, any one of them, had any justifiable reasons not to appear before the Senate. And none has been brought to my notice, if at all they have sent any such explanation. Mr. Speaker, you know, there was a famous American jurist who said that, you know, the breakdown of law and order does not start by very serious breaches of the law. They start by little violation, which end up, polluting and contaminating the whole public order and good governance. And therefore, this is not an idle matter. This is a constitutional violation. And the consequences of this in terms of what is required of public officers, if you look at the article in the Constitution that defines who is a public officer or what is a public office, Cabinet Secretaries qualify because a state officer is a public officer. And all these laws, therefore, apply to them. Now, I want to talk about a situation where in the past, even in the old parliament, there were committee systems. There were committee systems, but they died. And they died because there was one time, I remember when the committee on public accounts of the National Assembly, and there was also a joint committee of Foreign and Defense Committee, summoned the relevant ministers. And in respect of of the Public Accounts Committee, they had required what was called the Big Five. I think the Attorney General Emeritus, you remember there was a time when the Big Five would be required to appear before the Public Accounts Committee. And the executive at that time was very happy with the Big Five going to the Public Accounts Committee, but not to any other committee of the House. So when ministers were summoned to the Committee of Foreign Affairs and Public and Defense, and I think at that time Koigi Wamwere was the chairman, and if I'm wrong, then he was the chairman of the Public Accounts Committee. The president at that time said, how can Parliament summon a minister, my minister? Parliament cannot do a thing like that. And by that pronouncement, Mr. Speaker, the committee system died because by executive fiat, we were told you can never summon a minister. And it looks like if we continue like this, ministers will begin to say that, you know, we have no powers to summon them. They can come when they want. In fact, they are already conducting themselves as if we don't have those powers. And you call them and they say, you know, the Senate does not have those powers. I think the excuse now, which they keep on repeating, is that Senate has no responsibilities when it comes to the national government. But the Constitution is clear. The Constitution does not make a distinction as between the powers of the National Assembly and the Senate, or the committees of the Senate and the committees of the National Assembly, that both houses or the committees of both houses have powers to summon cabinet secretaries. And it's not for a reason that specifically the power to summon a cabinet secretary, it is provided for in the Constitution. If it was something in the standing orders or in the Powers and Privileges Act, probably we would not take it seriously. But this is a matter that is provided for in the Constitution of Kenya. And if for any reason we are to tell the public that we cannot be able to explain what has happened in regard to these increases on the cost of fuel and electricity, if we were to go to the public and told them that, we failed to summon, or the ministers failed to appear, then the authority of Parliament would collapse. And therefore, I invite the House on this regard, that on this first component of this motion, this first component of the motion, that we censure these two cabinet ministers. And it has nothing to do with politics. It's like being summoned by the court. You receive a summons from an appropriate authority. You are summoned by the investigative agencies. It has nothing to do with politics. It has nothing to do with religion. When Parliament summons you, and in the committee of the House, we got members of all shades. When you're summoned to appear, you have no duty, if you're a cabinet secretary that has taken the oath of office and knows his responsibilities under the Constitution and the law, your duty is to appear. And I think Kenya, at least we should be showing good examples to our neighbors. But it looks like now it is our neighbors who are giving us these examples. We should be leading from the front, but instead, somebody goes to Zambia. We have just had a report here on the elections in Zambia, and we are very happy about it, how in Zambia they could have free and fair elections. We could have access to the register without interference. Some people cite, like I've cited South Africa, where the president is summoned to appear before Parliament or a committee of Parliament. He appears. He is summoned by a commission, like the Zonda Commission, that is looking into state capture. Ministers appear, presidents appear, former presidents appear. So I do not see in Kenya the special case for cabinet secretaries to choose to come to Parliament or not, that we leave it to their discretion. I think we must tell them that this power that is given to Parliament is derived from the Constitution. And if we do not use that power to ensure that there is transparency, accountability, and transparency in the conduct of business of Parliament, then the whole democratic constitutional structure would have no meaning. And therefore, on this first component, I invite you to agree with me that the conduct of the two cabinet secretaries requires a censure. And I think we should not be in the business of trying to determine whether it was an invitation or a summon. Because the Constitution, the law itself says you can invite or summon. And the Senate has been so kind, our committees have been so kind. They invite, they give you a certain number of days to appear, and then subsequently summon. The choice, the discretion is not to the cabinet secretary. The discretion is of the Senate or the committee to decide how you are going to be made to appear, through an invitation or through a summon. That word invitation should not be read in its popular parlance that It's like you're being invited for a tea party. You are being invited to an important business of state which you must perform. So on this first limb of the motion, is actually the second limb of the motion, I invite all of us to censure these two ministers. And of course, the consequences of it, then the relevant committee, since it was under the direction of the relevant committee which was dealing with the matter, sanctions should be taken against the two cabinet secretaries. It should not just be this resolution by the Senate in plenary. I think there must be some sanctions, and the punishment is set out, as I've read, in the Powers and Privileges Act. And Mr. Speaker, you know, the problem with this particular matter is that the invitation was not just by the chair. It was through the order of the Speaker. You are one of the state officials, very few, that when you are presiding over our deliberations, you wear a special dress of honor. And in the order of things, looking at the order of, in terms of protocol and seniority, Mr. Speaker, you are so high up. You're so high up that when you speak, you know, heaven and earth should move. It is, the Speaker is there very high up in the order of things, both as a member of this House and the Speaker of Parliament. Now, on the second one, Mr. Speaker, I don't want to say much about this because already the out there is crying. And many members have expressed themselves, even yesterday, during the debate on the cost of fuel and electricity. Every one of us have talked about the fact that these prices or escalation of prices and costs of fuel and electricity is unbearable. And Mr. Speaker, I've tried to look for all sorts of literature available from official sources, from publications from all over the world, up to this morning. And it demonstrates that the cost of fuel in Kenya in relation to other countries is extremely high. Is extremely high. Indeed, by the communication made by EPRA itself, it categorized our fuel costs as one of the highest in the continent. And I cannot believe why costs of fuel in Kenya should be higher than Uganda. There must be some explanation for that. And Mr. Speaker, in fact, on this matter, all these publications agree, and leaving out the oil-producing countries, which are quite a number in Africa, including Nigeria, Angola, whose costs are lower in comparison to Kenya. But I would not understand why a country like Swaziland, the cost of fuel in Swaziland are better than those in Kenya. Why the cost of fuel in Namibia, Mozambique, the DRC, a country which has experienced a lot of problems. I know it has got a small enclave where there's oil, Kabinda, but that enclave is perpetually in a state of insurrection. Tanzania, Zambia, Rwanda, Burkina Faso, Ivory Coast, maybe it has oil, I don't know, Malawi, Uganda, Cameroon. In fact, in that list, in more than about 50 African countries, we stand at about number 30 in terms of cost of fuel. That requires some kind of explanation. And I am glad that the Secretary of the Cabinet Secretary in charge of petroleum, in one of his interactions with the Parliament, I think on the 14th day, Monday the 14th, 2021, Secretary Munyes is quoted as urging Parliament to review taxation on petroleum as the best option of cautioning consumers from a rising energy costs. So it didn't talk about the pandemic. It didn't talk about anything else. It said it is Parliament who has got that responsibility. Now, Parliament does what it is always required to do under the law. It gives the minister or the regulatory authority some discretion. But that discretion must be applied in a manner that does not cause, unhappiness or cause unnecessary burdens on the people. Why would EPRA, in the current circumstances, decide to increase the prices of fuel? It is not because of legislation, because that power that they were given as a regulatory authority must be administered in a way that is conscious or takes into consideration the condition of the ordinary Kenyans. I must say that that this time around, I must agree with the National Assembly. Arising out of the proceeding yesterday, they are required, at least by the direction of the Speaker, that they come with a report within 30 days, the Committee on Finance, with a draft legislation on how to deal with this rising fuel costs. And I remember the last time when there was a question of debt and the question of the levy, petroleum levy and VAT. We did make noise as a House, but we didn't have those tools with which to make an intervention. And Mr. Speaker, probably I may conclude by saying this. In the United States, the powers of the Senate came over time. The kind of sibling rivalry between the two houses was there in the United States as it is here now. And most of the powers, including budget making, were with the House of Representatives. But over time, they have realized that if you include Senate in some of these issues, including even the process of budget making, then you are better off than dealing with it as one chamber. For example, if taxes are increased, it affects counties, without a doubt. And I do not see any reason why Senate should not be involved. If taxes are reduced, similarly, counties will be affected. And when it comes to national revenue, where we have an entry point of determination of the share, horizontally between the national and county governments, that we have some role to play. But I think the most important duty of any parliament is the issues of taxation. And I think this should be a shared responsibility in time. And we'll never stop making that case, as observed by the Supreme Court. And, Mr. Speaker, I want to conclude by saying sometimes building a big house, you can build a big house, but if you have nothing inside that house to eat, you'll still not resolve the problem. In Kenya, I think it is good that we are working hard on our infrastructure. It's good for the economy, it's good for the people. But if the people's pockets are empty, or if the standard of living is too high for the people, or the cost of living is too high, then some of these major capital expenditures we are making may not benefit the people at the end. So for the future, our government should be very clear on the issues of debt and on the issues of taxation. As I said yesterday, the American Revolution was, was based on the question of taxation. Somebody said taxation without representation is like tyranny. But I say that over-taxation, like I said yesterday, is slavery. If all you're working for in your life is consumed by tax, then your spirit for hard work will be eliminated. So the authorities must always be thinking that as you want to do certain things which may be good for public good, you must always be conscious of the fact that people need to eat, people need to have shelter, and people need to have good hospitals and medicine, and people need clothing. For example, Mr. Speaker, there are people in this town, and Senator Sakaja is a better place to talk about this, but there are a lot of people in this town who earn 10,000 shillings a month. Now, if you're earning 10,000 shillings a month and the cost of boarding a matatu goes up by even 3 shillings out of that 10,000 shillings, we can be talking about this republic, what good things we are doing, but for that man who has to pay an extra 3 shillings out of 10,000 shillings for transport, return, and even if it is 50 shillings or 100 shillings, 3 shillings on top means a lot. And fuel, so long as you increase fuel, you're increasing the cost of foodstuff, of medicine, of transport, and even of housing. It is a commodity, it's a primary commodity. It's not a commodity that one can say it affects only one sector. Even in terms of production, fuel and cost of fuel and electricity are primary. They are primary towards production. And if you want people to generate more wealth, you have to be very careful how you increase cost of fuel and so on. And I hope that at the end of this, we by resolution, we censure, and secondly, we urge the National Assembly to speed up the legislation, the contemplated legislation to deal with this matter. And Senate probably can make a representation by way of a message that legislation is required like yesterday. With those remarks, Mr. Speaker, I move and ask Senator Wetangula to second. I thank you.